Good evening, everyone, and apologies for our late start. We've had a few technical issues with Zoom there, nothing to do with the fact that John's in Scotland and I'm not. Nevertheless, we are
Well,
here
to be
now.
fair, Julie, it might be to do with the fact that I'm in Scotland, to be honest.
Okay,
You've had
well,
major fires
whatever.
in my village over the weekend with Nick Nairn's restaurant falling down. Who knows what's going on?
Well,
But anyway, ladies and gentlemen,
we're here.
everyone, we are here, so I do apologise for the late start.
As usual, ladies and gentlemen, we are talking this evening about legal costs in construction litigation, adjudication and mediation with Mr. Jon Sharp. And if you have any questions that you'd like to raise or like Jon to answer, please don't hesitate to use the chat or Q&A tools in the bottom toolbar, and Jon will endeavour to answer as many of these as possible at the end. So, Jon, without any further ado, shall we proceed?
Yes, please. Let's go to the first slide, Julie. Right. There seems to be some sort of mystery about legal costs, but one thing we don't do is put them into a cauldron and then start mixing them up and then coming up with an answer. There is a basis upon which all solicitors charge, and indeed we are regulated about. Next slide, Julie. And we do not rob people. We are not some sort of person that steals from pension funds and then gets fallen off boats, allegedly. We do things properly and sensibly, despite the fact that probably we are the most unpopular profession, apart from probably dentists and estate agents. I think that's probably fair comment. Next slide, Julie. So this is what we're going to look at today: hourly rates, fixed fees, damages-based agreements, no win, no fee, contingency fees, engagement letters, adjudication against litigation, and then third-party funding. Next slide, Julie, please. Right, we normally, as solicitors, charge on an hourly rate or part thereof. It's divided into 6 minutes. Now, the hourly rate obviously varies between the firm of solicitors that you instruct. Some solicitors, magic circle firms, for example, will typically charge now for a partner expertise in his area of between $6.50 and $7.50 an hour. But the rate depends on seniority and location. So, for example, if you are employing someone from Slaughter and May in the middle of the City of London, who's a specialist in this area, as I said before, you could typically expect to pay $7.50 an hour, or part thereof. That's the normal way now that most solicitors charge. In days gone by, there was legal aid, but the legal aid system has gradually been eroded by various governments for various reasons. And so legal aid is now really only available to those who've absolutely no money, no savings whatsoever, and very little access to any form of cash at all. But you can help as clients if you are to instruct a solicitor, and let's face it, we don't all get up in the morning and think, oh, I know what I'll do today, I'll go and instruct a solicitor. It's not something that you really want to do, because normally there's a problem. There's been a breach of contract. You've been arrested by the police. There's an issue here. It's not a question of you getting up and thinking, oh, that's what I'll do today. No, you might do if you're making a will, and you have little choice if you're trying to buy a property. But if you're working on a time-based system, then It helps me enormously if you get clear instructions with ordered papers so that I can understand what the problem is. Okay. Also, do not ask and send long emails to your solicitor unless you think he's missed the point entirely. Apart from the first one, which should give a clear explanation of the situation, try and keep them short. The more time I have to spend reading an email, unfortunately, the more time I charge. But the key to it is to give clear instruction, ordered papers, and explain what's happened. That's always the best way. Next slide, Julie. Fixed fees. Well, fixed fees are basically, it does what it says on the tin. There are certain types of legal work where normally a fixed fee is quoted. It doesn't happen too much on contentious matters, so where two parties are arguing against each other. It really doesn't apply there because I don't know how awkward the other side's going to be or how cooperative they're going to be. But you will certainly get fixed fees in property matters and sometimes in employment matters. So the property team will say, to sell your house on the basis this is a straightforward sale will be £750. Yeah. Now, if I'm asked to advise on a litigious matter and it's on a very narrow point, then I may say, okay, well, to give you the preliminary advice, the fee will be X amount. So it might be £2,000, yeah, but it's then fixed. But no fixed fee tends to extend beyond the anticipated work. So again, I'll come back to me because it's easier for me, I think, to explain. If I'm asked to advise on a contractual clause in a contract, then I will be going, okay, to advise on that clause, given the background you've given me, will be X. But if then there are lots of further questions, or perhaps I've asked in my advice for some further documentation, then I will be asking a little bit more in fees. It's the same with property work. If a fixed fee is given on a straightforward house sale, so there's nothing to worry about, etc. But on the other side then say, well, hang on a minute, what about the church that was built next to the property? Did you take out what's called chancel insurance? And the answer to that is no. It may well extend the boundaries under which the quote is given. But my advice would always be to try and get a fixed quote if you can. But it does depend on the situation. Next slide, Julie. Now, because of the effectively collapse of the legal aid world, everyone has tried to help. And I know you probably won't believe it, everyone, solicitors have tried as well, to try and make the cost of access to justice a little bit easier. So, one of the solutions that we've come up with is what's called damages-based agreements. So we take our fees out of the damages recovered. What our fees are still based on our hourly rates. But of course, like any business, I do want to make sure that I get paid. So I'm not likely to do a damages-based agreement unless the chances of success are 80% or possibly better. So I will give an example of one that I did. There was a house that deceased parent lived in. They were trying to sell the house. They did everything correctly, kept the heating on to keep the house ticking over. But unfortunately, it was a very cold winter, and the pipes burst. Now, an insurance company said, well, we're not paying. The insurance policy was quite clear that it would pay in those circumstances. So I was happy to do a damages-based agreement with my client on that basis, because I was going to win the case. Similarly, on a personal injury case, if you are crossing a road on a zebra crossing and a motorcyclist comes up and hits you and you're on the crossing, chances are you are going to win. And if you really have no prospects of success, and for various reasons, no prospect of being able to provide any funding, and that for whatever reason you haven't been able to get legal aid, then a damages-based agreement might be suitable. Next slide, Julie, thank you. There are some cases whereby you may get a no-win, no-fee deal, but I would advise anyone that was entering into these to read the wording exceptionally carefully. No-win, no-fee comes from a term in shipping because the salvage industry, so these are the guys that go and try their best to save lives, ships, vessels, cargo, and nobody else will. And because the courts have always encouraged volunteers effectively to go to the aid of people, the courts salvors tend to get no win, no fee. So if they don't save the vessel, they don't get paid. So that's where the concept comes from. No win, no fee is typically used in personal injury and medical negligence claims. But again, it depends on the value of the claim. We won't be doing any form of claim unless the prospects of success are probably 80% at least. So again, going back to my previous example, you're on the zebra crossing, bike whizzes up the side, knocks you over on the zebra crossing, yet you are going to win. It's just a question of how much. But beware of the wording. Very often in no win and no fee, and indeed on damages-based agreements, says that if you unreasonably refuse to accept a reasonable offer, then hourly rates start to kick in. Okay, so you need to read the wording of these agreements. Next slide, Julie, thank you. Contingency fees, again, in an effort to help people get access to justice. What we have done is to say, okay, we think you're going to win this case, but we're not 100% sure. So what we will do, because to assist you, is we are going to charge a lower hourly rate than our average. We might halve it, for example. But if we're going to halve our hourly rate, and it will be done on the basis that you pay that halved hourly rate, we will want, in effect, a bonus at the end. But again, we won't be doing contingency fees unless you've got at least a 50 to 60 chance of success. Next slide, please, Julie. Now, All of those agreements should be set out very clearly in what's called an engagement letter. And as Julie will know, one of my favourite expressions whenever I give a talk is to read your policy wording. Well, an engagement letter is no different. You need to read your engagement letter carefully. It is normally a lengthy document, and it attaches to it terms and conditions of the company. If you don't agree with them, then you should be raising those questions at the start of what we describe as a retainer, but it's effectively the contractual agreement between you as a client, as a firm of solicitors. So as I've said there, if you're not set, it should set out in an engagement letter what fees are going to be charged. So if it's on an hourly rate basis, what the hourly rate is. If it's on the basis of a damages-based agreement, contingency fee, fixed fee, that should all be very clearly laid out. So don't ignore it. If you're not sure, ask. Because without you having received at least an engagement letter, no fees can be charged. However, if you do receive an engagement letter and then you continue to instruct that firm of solicitors, you will still be charged on the basis set out in the engagement letter. So, by not signing the engagement letter, it doesn't mean you cannot get away with paying fees. So it's an important document. It should be read carefully in conjunction with the firm's terms and conditions. Next slide, Julie. Now, the solution. Well, certainly in construction matters, adjudication is a fast, effective, and straightforward means of dealing with construction disputes. Okay, there's various criteria that you need to be able to use the adjudication method, but it's common in JCT contracts, it's common in straightforward house builders contracts. Now, you pay your lawyers, win or lose. You will not recover any costs from your opponent. Now you need to contrast that situation where if you go to court and you win, you can expect to recover between 60 and 70% of your costs that you've paid to your lawyers, including full recovery of court fees and disbursements. So that will typically be counsel's fees. And you will recover interest on sums outstanding from the date the debt is due, but that is actually common to both adjudication and litigation. If you win, you get the adjudicator's fees paid by the other side. So the losing party tends to pay the adjudicator's fees. It's very cost effective for large amounts of, if there's a very large amount in dispute. Going to court when there are millions of pounds between the parties racks up costs very quickly. Adjudication is also quick. You normally get a decision within 2 to 3 months, even on millions of pounds claims. Any form of litigation involving large amounts of money will take at least a year. In adjudication, there are no court fees. Remember court fees. They used to be reasonable, certainly when I started, but now over a certain amount, which I think is 100,000, it's now 5% of the total sum claimed. So if you're claiming 10 million, I'm sure you can do the maths. And that is what goes to the court. That's before you've started. And remember, there's a sting in the tail of litigation. Liability for the defendant's costs if you're unsuccessful. So you sue someone, you lose, you'll be paying a proportion of their costs, as well as your own. So remember that. Adjudication is not suitable for everything, but it certainly can be. Thank you, Julie. You've read my mind as always. Now, the insurance market has tried to assist with legal fees for some considerable period of time. It started in 1999 when Lord Justice Wolfe effectively said, I'm sorry, we are going to have to, basically, with the end of legal aid, the insurance market tried to assist. Lord Justice Wolfe made matters even worse. So the insurance market said, well, look, we will provide some funding methods to also assist. However, the initial idea where effectively insurers would pick up part of the defendant's tab if you lost has now long since gone. Lord Justice Jackson in 2009 said that, I'm sorry, you can no longer recover your insurance premium from an unsuccessful defendant. But the insurance market still has some innovative, never say that word, solutions to funding litigation. So let's have a look at third-party funding. Third-party funding would typically be where they provide funding for a portion or all of the costs of conducting a claim in return for a share of the damages if the claim is successful. Funding is non-recourse. If the case is won, the third-party funder receives its money back plus a portion of the damages. So it's risk-based. However, if the case is lost, the third-party funder does not recover its investment. Next slide, Julie, thank you. So what is third-party funding? Third-party funders provide funding for claims of all sizes. Funding is available for claims conducted by arbitration, litigation, and adjudication. Funding is available for all stages in the dispute resolution process. Claim preparation, statements of case, submissions, mediation, hearing, and enforcement. And funding is available for individual claims, and it's also available for portfolios. By that, I mean, probably the best example at the moment is the emissions scandal, whereby allegedly Volkswagen and others have lied to people about the level of emissions that their cars did, allegedly. Next slide, Julie, thank you. Well, what are the benefits of funding? So not funding it yourself. So you may well be in a company that's lucky enough to have the resources to fund its own litigation. But what are the benefits of going to a third-party funder? Well, companies are able to monetize claims without downside risk. So you can say, well, I think this one is probably worth a go, but what's the downside for us? So it increases cash flow. Reduce legal expenditure, again, frees up cash flow for core operations and investment. Funding is recorded off balance sheet, so it's got a neutral impact on the financial position of the claimant. The claimant receives the benefit of the claim if it's successful, representing a risk-free source of revenue. Not quite sure that's right, but it represents a, I've said risk-free source of revenue. You can still lose, and there are circumstances where you can still end up paying the costs. But your legal department, if it's got a good funding operation, can shift from being a cost center to a positive source of revenue for the business. This is good for the directors and owners of the company. Legal departments traditionally have been a drain on resources. Get a good funding provider, and yeah, I still think legal departments will be a drain on resources, but it might lessen the impact of that. Next slide, Julie, thank you. Access to justice. I do hang on a little bit about access to justice. Having done this job for 33 years now, increasingly the access to justice that everyone has, and doesn't matter what size of corporation you have, has been gradually eroded. Everyone, no matter how big, small, large you are, should be able to afford quality legal advice. And that includes companies, and it gives them the ability to pursue legitimate claims that otherwise they could not afford to fund themselves or justify. If you have funding, you have an obligation to tell the other side that you've got it. And funders will look at your case from a commercial point of view, and if they've decided to fund it, it gives a very strong indication to the other side somebody else believes in this case, and you're not going to be able to get rid of the case by simply having a war of attrition, a David and Goliath scenario. As I said, its strategic advantage is the disclosure of funds sends a clear, positive signal to both parties on the strength of the case. It may incentivize settlement, because what you're saying as a claimant is it's not just me that believes in my case, somebody else does as well. So from a client's perspective, there are key variables: process, price, timescale, ongoing involvement. Next slide, Julie. But they have to go through a due diligence process. So they are likely, there's a likelihood of success and anticipated damages. So they will, third-party funders will want an opinion on the prospects of success, an assessment of realistic quantum, enforcement and recoverability. There is no point in pursuing someone who's insolvent. You are just throwing good money after that. So third-party funders will look at the solvency and asset position of the respondent, and they will want to see that there is a good strategy for enforcing judgment. There needs to be a clear budget for conducting the claim. There doesn't necessarily need to be a minimum or maximum budget size. If you recall very much earlier in this talk, I said that litigation is virtually impossible to predict. It depends on the attitude of your opponent. But normally the ratio of budget to damages must be at least 1.6 for funding to be viable. Next case. Sorry, next slide, Julie. So there we go. There's a typical milestones for a third-party funder. Notification received from them saying, I'd quite like to see if you could look at some third-party funding, please. They will then send you some commercial terms. There will be initial due diligence done on you as an entity as well. Then you'll agree some term sheets. Then we'll get an opinion on prospects, preliminary report on quantum, external legal review, normally by the third-party funders' lawyers. There will then be an investment committee meeting by the third-party funder. So that's where they say, yes, we'll do this, no, we won't. Then you get a funding agreement executed, and then there's ongoing monitoring of the case going forward. Next slide, Julie, thank you. Common issues in construction. Construction disputes are unique and expert evidence is often required. You all know that. And at an early stage to determine strength and quantum of the claim. The parties often have multiple claims and require a business-wide financial solution. Many construction claims vary in size and are dealt with via adjudication, as well as litigation and arbitration. Next slide, Julie. Early stage funding is available to assist with the development of a claim to the point that it may be eligible for full funding. So you might, if you have a good funder, get a little bit of money up front. It's suitable for claims that have primary facies strong prospects of success. And early stage funding often depends, however, on counsel's opinion, experts' reports, legal costs, so how we investigated the claim, evidence gathering, and book build activities. So ESF is an inherently riskier investment than full funding, and for this reason is subject to a higher success fee. So probably the best thing to do is to wait until you've got all your ducks and drakes in order before you approach a third-party funder. Next slide, Julie. Pricing and, oh, you've ahead of me again. A typical TPF return is generally equal to one of the following: a fixed multiple based on the funds drawn at the date of resolution, a fixed percentage of the total recovery. The fixed multiple is calculated by reference to both the length of time from the date of execution of the funding agreement to the date the case is resolved, the amount of the facility that has been drawn down at the date of resolution to reflect the length of the TPF investment, and to incentivize settlement, the fixed multiplier is lower than the earlier that a claim is resolved or settled. Right. Shortly, all that means is that if it settles earlier, third-party funders take a lower percentage of the damages. If it doesn't settle to the door of the court, third-party funders take more money because, guess what? They spent more money in getting it to the door of the court. Next slide, Julie. So you've got a claim description, claim arising out of the breach of a joint venture agreement, amount claims 40 million, you get a facility of 2 million to take it to court. There you go, there's a nice slide that shows how much you get, how much you've drawn down, what the uplift is, the nearer it gets to court. Next slide, Julie. So here's a hypothetical resolution 2. There you go. And 3, Julie, I think there wasn't a 3. I thought there was a 3, Julie, but you're ahead of me. The conclusion really to all of this, ladies and gentlemen, is that there are methods in which you can at least try and ameliorate your legal costs. There is no hiding behind it. Legal costs are high, especially in the construction industry, where documentation and contracts tend to be complex. From my viewpoint, as I'm now a qualified civil and commercial mediator, I always think mediation would be a good solution to any dispute. But adjudication is equally effective. It reduces your risk. Even if you lose, you don't end up paying the other side's costs. However, if you have significant claims, you should be looking at third-party funding, because it takes away the cost impact on your business, but actually a relatively minor sacrifice of what you might recover. And on complex claims where you are fairly sure you're going to succeed, you should be asking your lawyer to look at third-party funding. What are the options? Again, third-party funders are not stupid. They won't back a horse that's still going to be running when everybody else has finished, but they will back one that might come third or fourth, and that will save you some considerable time and effort and money in legal costs. Now, ladies and gentlemen, I do hope that's clear. I do apologise for the late start. I also apologise for not having my shirt and tie, which I normally do. But I'm afraid to say it's so hot in Scotland that I couldn't put one on.
How terrible, John. Thank you for that update. And thank you indeed, as always, for injecting the words, read your policy wording, even though it wasn't directly related to insurance policies. Good job. Well done, you. You've won the bingo. As always, if you have any questions for John, now's the time to pop them into the chat box or the Q&A tool. Otherwise, we are next online with John next week, I believe, when we have an update to his ongoing saga with COVID versus the insurers, those business interruption claims, and obviously following the conclusion of the FCA test case and the various appeals. John's going to be giving us an update. That is next Wednesday at 6 p.m. Tomorrow we're back online with Mohammed Haq and his new series, Changes in Construction Contracts, Valuation and Other Implications. So in either case, if you would like to book a place on either of those, please do not hesitate to email seminars@fletcherday.co.uk. And indeed, if there was something you'd like to ask John in regarding to any of the issues he's been discussing tonight, but you didn't particularly want to raise it in an open forum, please feel free to email him on jon.sharp, that's jon.sharp @fletcherday.co.uk. So all it remains is to say thank you to John and thank you to everyone for attending. And we look forward to seeing you all again very, very soon. Thank you very much, John.
And I apologise to everyone for being late again.
Not a problem. Technical issues happen. I'll find those gremlins and have them shot.
Thank you, Julie.
See you soon. Bye-bye.